Good morning and welcome to the ODPP Café. The show is brought to you courtesy of the Office of the Director of Public Prosecution. The show is meant to educate and inform you. And of course, because we say knowledge is power, we intend for you to understand how the law works and also how to apply it in your everyday life. The show is live on Facebook at the Office of the Director of Public Prosecution. We are also on Twitter at ODPP_KE and on YouTube at the Office of the Director of Public Prosecution. We welcome you to subscribe, we welcome you to follow our pages and of course engage with us, ask questions because they're experts always on standby waiting to respond to your question. As always, we will take you through a roundup of the courts and with a disclaimer that it's not everything that happened, just a few highlights just to show you what has been happening in the courts. Have a look at this. So this week we're going to run the show a bit differently. 2 weeks ago we had a show on the rights of victims and accused persons. And I had a team of experts. The challenge we had was technology and the internet. It failed us. So we got a lot of comments and requests from our followers and members of the public who are trying to follow the show and were not able to. And they asked us to just do a rerun of the show because of course we did a recording. So this week this is what we're going to do. We're going to take you through what happened that week, the whole discussion. And as usual, like I say, ask your questions, type out your questions. Somebody is going to be available to respond to your request. On the show, we had Mr. Riechi Meroka, a Senior Assistant Director of Public Prosecution, and Vincent Kimathi from the ICJ. Both were talking about the rights of the arrested and the rights of the victims during the trial process. It was a very interesting discussion. I invite you to engage, understand, and of course, ask questions. Thank you so much. Have a look at this. Well, we get into the topic today, and it's not actually a topic today. We've been having this topic on Twitter and on Facebook, trying to just sensitize you about the rights of an arrested person and the rights of the victims. A lot of discussion on Twitter has taken place about what happens when somebody is arrested, or what happens when I'm a victim of a crime. What does the law say about me as a victim? What does the law say about me as an accused person? We've discussed this on Twitter. You've seen your comments. We've tried to engage you. But today I have in my studio, two experts, one from ODPP and another one from ICJ. Yeah, so we are discussing the rights of the arrested person and the rights of the victim. And we just want to be sensitized as the public to understand exactly what are these rights. What are the Bill of Rights say about the arrested person? And what does the Victim Protection Act say about the victim? So maybe, Mr. Meroka, maybe just let's start with the journey of a suspect. How does it start?
Thank you.
Yeah.
For us to understand the processing of a suspect to leading to being an accused person, we start with at the time of arrest.
Yes.
And what is arrest? Arrest is a confinement of your restriction of movement for purposes of being suspected to having committed a crime. Mm-hmm. At this stage, all you have is to be informed that you are under a restriction for purposes of committing an offense. Mm-hmm. And who can do this arrest? Mm-hmm. One, we have the mandate under the National Police Service. Mm-hmm. They have unfettered discretion to effect arrest to prevent a commission of a crime. Mm-hmm. The second team of people who have the mandate to effect arrest are institutions that have specific functions for the protection of public health, public safety. Mm-hmm. We have the public health, we have the Anti-Corruption Commission, we have the Office of Migration, and many more, even Kenya Wildlife Service. They can effect arrest.
What is to effect arrest?
To effect arrest is to restrain a person, to restrain a civilian from either continuing to commit the offense or from running away from the crime that he has committed. And then bringing him closer to the wheels of justice to take its own course.
So, the public can actually effect arrest?
Yes, the public can effect arrest.
Okay.
The national government, through the Ngao, the county commissioners, and officers below him.
Who's Ngao?
The Ministry of the Interior, Interior, or the Office of the President. Yeah. They can effect arrest for purpose of preventing a commission or an attempt to commit an offense. But the difference of them is that they must present this person to a police station for purposes of officers at the police station receiving the suspect and now making a re-arrest. Now, at that stage, we call it a re-arrest because it is a secondary arrest arising from other institutions. Now, it is at that stage that this person is retained at the police station or booked for purposes of processing.
Okay.
What does it require? What are his rights at that stage? One, he needs to be informed that he's being restrained. He also needs to be informed who is restraining him. The officers need to identify themselves that it is us, police officer number this, from this police station with the mandate to restrain you. And number three, at this stage, he has an option to seek for a legal representation.
Okay.
He can ask to have his own advocate in this issue. And when he reaches at the police station, it is also his right to be booked in. The reason for booking him in the OB or Karen's book is to start having a sequencing of his detention procedure.
So being recorded in the OB is very important.
Being recorded in the OB is very important.
So the question is, when you say the officer must inform the person about why they've been arrested, who they are, and this is what you call the Miranda rights. We hear them on TV.
Yes.
Even in Kenya, they're called Miranda rights.
No, we don't call them though.
Yeah.
But they are the same.
Okay.
And what this helps, you might not get the full explanation of why it's happening, but you must get a snapshot of why you are being restrained. Okay. It is a curtailment of your right, and it's necessary that you be informed at the bare minimum that we have arrested you because so and so made a complaint that you stole his cow.
Okay.
Now, the reasoning why the more greater detail can be made at the police station. But at that level, all you need, the basic one for the rights of the suspect, is being informed who is arresting him, being informed that
Why?
he's being detained, and a right to his representation. And more importantly, if he wishes to speak, that the information might be used against him or might be in his favor.
Okay. So Vincent, vitu
Yes.
kwa ground ni different. Does this always happen?
Okay, I will say they don't. It is a fact, but the reality of things is in Kenya, most of the arrested people, they'll just be roughed up, taken to police stations, and in fact, we've had cases where most people are not booked. There are no OB numbers against them. So when they are in the police cells, when you ask why are you in there, you'll be told even you're not booked. So my understanding is we've seen a criteria where police cells are used as intimidation
Yes.
places where, for example, if I have an issue with my senior here, I can speak to my friends who are in the police force, and he can be
Holding to the
taken, he
cell.
can be held into cells
Yeah.
without even being booked. So I think it is a culture we need to work on, because it begins, that is where violation of rights starts.
Yeah.
Because by the time you're restricting someone's, or you're refraining someone from freedom of movement, it shows already that you're already violating their rights.
Yes,
Yeah,
yes.
I think we need to work on that, and
Yeah, so we have the laws, but you're not applying it.
we are Anita, we have very good laws. Very good laws.
Yeah, I was in
But-
Kisumu just the other day,
Yeah.
and the joke, just before 7 p.m.,
Yeah.
the curfew, unaambiwa forget about your rights, my guy.
Yeah.
Kimbia nyumbani.
Yeah.
Kwa sababu hutaambia polisi, I know my rights. It looks like it's the worst mistake to ever tell a law enforcement, a person effecting arrest, that you have rights.
Yeah.
It immediately takes you into a different space.
Yeah.
Ile utajua haujui.
Yeah.
So the question is, what will make law enforcement officers actually apply the law?
I think first it is I think as a society first we need to create that environment where there is a free engagement between the police and the public. And
Tough call.
actually it's I will personally say I will commend the police service, because it is they've started opening it up to the
Yes.
public.
Yeah.
Because nowadays I can see police officers, and there have been cases where police officers have been on record even speaking to the public. You remember during the post-election violence, there's
Yes,
there's that police officer who was telling
Was
Kenyan
preaching
citizens,
peace,
why
yeah.
are you people fighting your neighbors? This is not the right way to move.
Yeah.
I think those are part of the things that show that we're heading at the right direction as a nation. However, police officers need to understand that they work for the people, and their work is not oppressing the people. And for purposes of having a good criminal justice system in this country, we need to have a police service that is accommodative to the public. Because actually, if you need to understand that the police officers play a very critical role in the criminal justice system.
The important actors.
In fact, they are the first people, they are the first organ, which is the right one to use. They are the first contact between the arrested person.
They initiate the process.
Yes.
Yeah.
So if the process is
Not
tampered
from
with
there,
from the beginning, then
Yeah. Yeah, I saw even Mudangari police station, they had like a Christmas party and invited the residents of Mudangari. And of course, it was met with a lot of skepticism, like wanajaribu, wanatafuta nani. And I think they were just trying to reach out. So we must commend them. They're trying.
Yeah, they are really trying, because
Yeah.
they are opening up to the public, which is a good thing.
It is.
Yeah.
So, Mr. Mcheka, let me ask you. I don't know if it's the right question to ask, but the mandate of the ODPP in as far as the accused person is concerned, and maybe the victim. I mean, how do you interact with these two individuals?
Thank you. Maybe I just wanted to, before I answer to that, there is a bit we missed of the obligation of the suspect.
Ah, he has an obligation.
The obligation of the suspect,
Yeah.
when informed that he's being detained, is to cooperate. And that is also a responsibility on him. We might, as much as we're discussing on the rights, it's also an obligation of the suspect to cooperate.
But you're being arrested. Why do
Precisely.
I cooperate?
The reason why you are cooperating is going to vindicate yourself that it is not you who committed this offense.
Yeah.
When you become militant, then either party will not understand who is at fault. So cooperation is really to their own benefit as well. And the reason why we are giving the rights is for purposes of knowing that this is your must do, but also you also have an obligation on the institutions, provided they have introduced themselves. It is pretty critical that that you also cooperate.
Yeah.
Now, on the mandate of the ODPP, it is derived from Article 157, or through from 157.1 to 11. Generally, it is the Office of DPP that has criminal mandate of all offenses within the Republic. What does this mean? That it is the ODPP that initiates prosecution of cases on behalf of the Republic.
They make the decision to
They
charge.
make the decision to charge, and they make it on behalf of the Republic. So when does this mandate start triggering, properly so called? It can start even when the arrest has not been made. The DPP has the mandate, upon receipt of a complaint, to write to the Inspector General for purposes of investigating a specific allegation, and revert back to him with the report of what has been transpired from the investigation. And it's on that investigation that then the DPP can make a decision whether this matter is of a criminal nature, and if it is so, then it can recommend that the charges be preferred before court.
Yeah.
So the mandate of DPP can start even before arrest. But when it comes, it triggers in after arrest. Secondly, I wanted us to mention the accused person, the suspect who is in custody, and what is his rights for purposes of the DPP triggering his power.
Yeah.
At that stage, he has an obligation to record his statement. The accused person, the suspect, has an obligation to record his statement. Why is that statement important? So that as the police are compiling a file, which was the victim or the complainant side of story, we can also get to a glimpse of what is the defense of the accused person or the suspect. And it's at that stage then, when that file is prepared and complete, it is brought to the DPP to reassess the evidence. And if the evidence meets the standards of within the parameters of the ODPP, the threshold test, the public interest test, then the DPP can make a decision that this matter is fit for it to go to court. Where it does not meet the threshold, the DPP has the discretion to revert it back to either cover further investigation, or to recommend the closure of the file because the evidence does not meet the criminal threshold, which the ODPP has a standard for.
Yeah.
That is why it is important for the accused person as well to give that information. When do you need to give it? During the recording of statements at the police station. At that stage, you also have a right as an accused person, as a suspect, to call your witness, to call your advocate in the recording of statement. You also have a right not to record a statement. It is a right. But if you choose to record a statement, then I've given a reason why it favors. Not necessarily that you are going to incriminate yourself, but you can present a version which was not within the purview of what the complainant brought out.
Yes. So at what point, just to cut you short, at what point does the DPP or the ODPP engage with the victim now?
Now, that's why I'm saying that after that stage, the file will be presented to the DPP. The file presented to the DPP will also have the version of the victim. It is through that version of the victim and all other evidence in the file that will make the DPP make a decision to prefer a charge. So the first interaction is already there.
Yes.
But that does not mean that it will be the only interaction with the victim. Subsequent to a trial, the victim has an access to the prosecutor throughout to know the process of his matter, to be prepared as a pre-trial of what intends, how the evidence will be presented before court, and how we need to structure it in the manner of presentation. So the victim has we can call it an absolute access to the office of the Director of Public Prosecution for purposes of knowing how the matter progresses.
Okay. Thank you.
Now, the second limb of when does the DPP now take charge of this matter? Upon receipt and preferral of a charge, assuming the evidence was sufficient, then it is the DPP who presents the accused person, the suspect, to court for plea taking.
Okay. The DPP who presents.
It's the DPP who presents the accused person to court for purposes of plea taking. At that stage, Anita, there could be two scenarios. Scenario one, that if the evidence is complete, then the accused person is given an opportunity to plead to the charge. Say, yes, is it me who committed, or no, it's not me who committed the offense. Then the other steps follow. But where there is no sufficient evidence at that stage, then the DPP has a mandate to explain to court that we can now release this person pending investigation, or we are praying for more time to allow us complete investigation before the Office of Director of Public Prosecution makes a decision whether to charge or not. So that's where the miscellaneous applications come in, to seeking the court's indulgence to give us more time. Why so? Because the suspect has a right not to be detained beyond the 24 hours. So you can only conform with that provision of the Constitution if you present the suspect before a magistrate or a judge and ask for more time.
Okay. So and maybe we'll just dive into the conversation you're having earlier. Why do we have to wait? Why do you have to get to court to ask for more time? Why can't we just finish investigations and go to court with a complete file? Like, why do we have to get there?
Two things. Most times, we don't need to get there. Because a file can be prepared and be complete. And then we make a decision to charge. But there are scenarios where the nature of the offense does not allow us getting all the evidence within the short time.
The 24 hours.
Within the 24 hours. For instance, if it was an issue of a suspect has allegedly committed a murder, we need to wait for the post-mortem report to confirm really what was the cause of the cause of death. And that comes from the government pathologist. If it was the use of firearm, we also need to get an assessment from the doctors that indeed there is a bullet wound on the body. Or the firearm experts have established that this gun is the one that discharged the bullet, which was discovered from the body of from the victim's side. So sometimes not all cases will have a watertight evidence at the time of making that judgment call. But that is why we seek for more time to allow ourselves prepare. The best scenario where cases are not of that higher threshold, we do not encourage restraining for unnecessary. The DPP has given direction that though we have the mandate to prefer miscellaneous applications, those applications should be done very sparingly because they are restraining the right of an accused person, a right of a suspect. So for instance, the minimum we start looking for is what is the level of the offense. Is it a murder? Is it a grievous harm? Is it certain serious crimes? There are only cases which we are now entertaining to allow a miscellaneous application for a custodial order. And even where the cases are allowing, we are restricting the days as low as possible to allow the investigator also compile a file. We are also alive that we are infringing, in quotes, the right of a suspect before making a decision. That's why we are really trying to balance how close can we go in terms of giving the investigation team sufficient time to investigate, as well as assessing that we are not infringing on the freedom of the accused, the suspect.
Yeah. So Vincent, tell me, what do you do at ICJ, and how do you interact with these two individuals, the accused and the victims, in as far as your mandate is concerned?
Okay.
Yeah.
You see, the biggest challenge that has been there outside here is before 2010, that is before promulgation, before we got the new constitution, we did not have the aspect of the victim in the constitution. So our constitution was majorly on the accused.
Yes.
But now with the new constitution, there's now the requirement under Article 50, sub-Article 9. Okay. There is now a requirement that a victim, that is the person who has been affected by the action that has
the crime.
There is now a requirement that they can appear in court and they can make statements in court, but it is at the discretion of the court.
They never used to do that before?
Before it used to be more of a prosecution who represents the state and the accused.
Okay.
Yes, but nowadays even there's a provision where they have to this impact assessment for the victim.
Yeah.
The victim is allowed to have an advocate who represents them in that matter, and they can present their case as well. And maybe my senior here can explain further on the relationship between prosecution and the victim's advocate, because actually, I feel there is a challenge there.
There is, and I want to ask this question, Mr. Miroka, that when the DPP comes into court, he says, you say the ODPP you're representing, I keep saying the DPP like it's the it's the person, but it's not. When the office of the DPP goes to court, they say it's the Republic versus the accused. So while I, Anita, as a citizen, I know that you represent me. You are the Minister for Justice. You represent my rights as a citizen. And maybe now I am the victim. So at what point, why is it the Republic versus the accused? Why is it not a Republic Anita versus the accused? Where am I as a victim of a crime? Because it feels a bit detached. It feels like victim really is not considered except up until when they give evidence, and then that's it. And of course we discuss the like Hassan calls it, the prosecutorial coup d'etat, when we have the advocate of the victim and the ODPP. How do you interact?
Thank you.
So Republic versus the accused. Where am I as a victim?
Why do we call it Republic?
Why?
It is drawn from the British system. It is the crown. And the crown, the intention of the crown is to administer on behalf of everybody. So whereas the DPP appears as an DPP is really representing the state, which includes the victim.
Okay.
Right? So the victim passes through the office of DPP as a mouthpiece of the commission of a crime. There are other crimes where the victim is not there. So we might not use the victim per se.
How would a victim miss from a crime?
The victim has died. So we are pursuing a case against a person who is dead. So then the DPP comes in, right, on behalf of even the living victim or the deceased victim. There are offenses where we do not have a victim per se.
Those ones are clear. Offense. Those ones are quite clear. But here, I am a victim. I am actually seated there, maybe for just picking a case. I was assaulted.
True.
We unaenda hapo nasema Republic. I'm like, na mimi?
Now you are. It is like, who is the Republic?
Yes.
Who is the state?
Yeah.
The state is everybody.
Okay.
Right? Yeah. Within the Republic.
Yes.
So we might not be narrowing it to the specific person, but the reasoning why we use the republic is he incorporates everybody. And for my cue, not all cases are purely for the interest of the victim. So the DPP comes in with another feather over and above the feather of the victim. But is the victim isolated from the trial? No. Because for a start, the victim has an obligation to make a complaint at the police station. And it is on that complaint that the investigation starts.
Yes.
The victim has an obligation to record a statement. The victim has a responsibility to assist the investigating team to recoveries or items that are beneficial to his case. And during trial, the victim has an obligation to tender that evidence in court. Because whatever we have in the police file is not evidence in court. So we need a mouthpiece who can present it to court.
This is the victim.
This is the victim.
But that's my question. You engage the victim in as far as giving evidence is concerned. And then
No. We are not isolating it. The reason why we are doing that, so that it is the victim who triggers the whole trial.
yes.
Right? It's the victim who triggers the whole trial. And where there is no victim, the state still triggers the whole trial.
Yes.
That is why some cases you might really find it's only investigating officers and other agencies that are prosecuting a matter. We do not have a victim in courts for offenses against corruption.
Yes. Well,
It is
that,
the
yeah.
state,
Yeah.
which is the victim.
Yeah.
So that's why the place of a victim is a very active participant in the whole trial. Is never subservient. And the law has gone further and said, okay, now you can engage your advocate, the victim's lawyer, or an advocate watching brief for purposes of to protect the interests in the court of the victim.
Yeah.
Now, that advocate comes in to present the versions of the victim to the prosecutor for onward transmission to the courts.
So, I have a question. You have allowed me to have my advocate. Then there is a prosecutor.
Yes.
Does this advocate also, are they given time in court to represent my view? Yes.
Yes. The advocate of the victim,
Yes.
other than the prosecutor,
Yes.
can address court, but has specific limited rights to address the court on.
Okay.
He can address the court on issues relating to bail, where there is a debate whether this person is fit to be admitted to bail or bond. He also has an opportunity to make a submission in relation to sentencing. Why is he brought into the picture? Other than a prosecutor who looks at the evidence and the bigger general good, the advocate for the victim can now bring in the specific challenges that how the specific pain that the victim endured from this commission of a crime.
Yeah.
It is through that he can now bring the humane face of that aspect of
That crime and even the victim. Yeah, that makes sense. Is there like a thin line? Is there a duplication of roles now? Because I have the probation, I'm the prosecutor, I have the probation report, I have done the investigation, I have the story. Why do I need another person to come and tell this story? I am sorry, this is very interesting for me. Yeah.
The moment a victim engages another advocate, then the advocate becomes the mouthpiece for that victim. So they are one and the same,
Yes.
strictly speaking.
Yeah.
And the moment the victim raises a complaint in a criminal process, then the prosecutor takes over that as a representative of the victim and the state.
Okay.
So there is no duplication. The only duplication would be, however, where there is a conflict is when the victim's advocates want to take charge of prosecution
Are you seeing those ones? Are there those instances?
We have been having a debate on how far should an advocate for the victim be participating in the trial.
Yeah.
The position has now been settled by the Supreme Court that yes, you have a right to access the court, but you can only access it on the premise of committing of the court. It's quite more different from the place of a prosecutor.
Yeah.
Because the prosecutor has access to court as a right. The victims have access to the court through the permission of the court. And that was not the position of Joseph Waswa. So it has somehow settled. But at no stage is the victim left lagging behind. Whatever the prosecutor is undertaking, it is for the furtherance of the victim's interest as well as the greater public.
Okay.
Well, maybe just to interject on the very good submission.
Yeah.
Maybe I don't know if it's more of a question or it's just a political. From what I hear, then the prosecutor has an obligation to ensure that they fully involve the advocate of the victim.
Yes.
Which I think might be the issue, because if the advocate of the victim is being secluded from the process, then definitely that will be what the victim will feel, and they will say, why am I in this thing if at all my views are not?
You're not seeing me.
You're not seeing me here. I have an advocate who should represent me. So I think it is upon the prosecution to explain to them, this is where we want you to interject, and once we get here, please let me do this. I think it's a matter of having that discussion between the advocate of the victim
and the prosecution. Yes.
Because I think once there is that clarity, I think the issue of duplication of roles will
not happen. I want to draw you to a video that was making rounds on social and I think even on TV. The case of Ivy Wangeshi in Eldoret. The mother made a very passionate plea to the state to consider the victims because they've been having hearings, we call them listings, in Eldoret. I think they live elsewhere in another town. So the whole family gathers up to go for the hearing, and when they arrive, they are told, there's no case today, there's a delay of some sort. So the question is, and that comes out now as delayed justice. And when you see people commenting on it on social, they assume immediately that the DPP has done something to scuttle that the day's process. So the question is, who should inform the victim's family or even the victim that hata usikuje leo kuna ka delay fulani? I mean, how should this happen? Because it is seen obviously as delayed justice, and justice delayed is already denied. Yeah.
Thank you, Anita. I think we must also lay a background, what transpires in each time.
Yes.
Sometimes we might blanket it and then lose the focus.
Yes.
There are scenarios where a case will be listed for purposes other than the hearing.
Okay.
But if the victims are not informed, they will come with an anticipation that they will give evidence.
So then what is listing?
Listing is the matter being on the court list to appear in court for that particular day.
Okay.
So for them, they might see the matter is appearing in court, but they are not privy why is it appearing in court, whether they are needed at that time or they are not needed.
Who should tell them?
Now, who should not tell them? It is actually the obligation of the prosecutor who communicates the same with the investigating officer. Because for us, where the victim does not have a representation, then the only avenue to reach the victim is through the investigating officer. Where there is an advocate on record for the victim, then now that communication should be done by the advocate for the victim to the victim's family. That today this matter is coming up for purposes of establishing that the accused person has recovered if he was sick. So then it is the victim's advocate who should be telling the family that today, yes, your matter is listed, but don't come because what we are going to do is for this reason. There are scenarios where the matter is scheduled for hearing, but when you read through in court, some developments emerge. Maybe the court, the magistrate or the judge is not available. So the matter will be taken to another court for giving a new date. But to them, they are not seeing the difference between the judge or the magistrate who was handling the cases then and this one. So they will say, why would it be taken away from today's court list? Because we are also seeing another magistrate.
Yeah.
Because the magistrate given mandate to exercise on that file is away. The second scenario, that either the part of the prosecution, there was evidence that is not yet available. So we cannot present that witness because that evidence is not yet ready.
Yeah.
So that would be it will cause an adjournment. Or where the accused person, the accused person advocate is not available. He might not be available totally for not coming. Or he might be sending someone else who comes to say, my advocate, I've just come in and I'm praying for an adjournment because Mr. So-and-so is not here. Or there could be scenarios where the advocate for the accused person is on a senior court. So if the advocate for that accused person is in the court of appeal, let's say in Nairobi, and the matter is in Eldoret, then priority is given to the senior court. Right?
Okay.
Those are the dynamics that can cause an adjournment. Where the reasons are flimsy, the court will always decline. And you have heard the court saying, you must proceed with the matter. Or, I'm giving you half an hour to prepare yourself and proceed with the matter.
I think that is what people want to hear more, that there's mitigation. There is help. When there's a lot of pushback and delay tactics, the court can say, imagine, tunaendelea.
Yes, it happens. It happens almost all the time. It's only that you now need to come and convince the trial court that I'm praying for an adjournment. And that adjournment must be reasonable. So if the court is not satisfied, it will tell you, I don't entertain that. I'm giving you a 15 minutes or 30 minutes or 1 hour breather. Prepare and proceed. Or I think those are the triggers that can make a case not to proceed. Not necessarily there is any ulterior motive on the part of the DPP that he has failed to exercise his mandate. Almost always. You will always find a prosecutor in court.
Always.
Always with that file, whether the matter is proceeding or not proceeding.
Okay.
And I think just to add on that, Anita, there's always there's a notion outside here that once I get an advocate to represent me in a case, then just leave the matter to the advocate. The advocate will deal.
Yeah.
That is a very bad thing. I think once you get an advocate to represent you, you have the right to go ask them, when is my matter coming up? Where will it be?
Be involved in the matter.
Be involved in the matter.
Yeah.
And if your advocate is not privy of that information, then they will just look over a way of getting to the prosecutor and they will just make a call and ask them, is the matter proceeding? Definitely the prosecutor will tell them, I'm yet to get the pathologist report. It might not, but I will give you a call to confirm that. You see, once that information is with the advocate has a duty to inform their client. And it is the obligation of the client as well to go to the advocate seeking this information. Because as you remember, you are paying that person for their services. I think the whole notion of Wakenya saying that stories are kotini, it is not our thing. Just leave them for the advocate. You see, you never access justice if you're not involved in this
the process.
Yeah. Because I've seen instances where for example, it's a day for example, a witness. You've been told we need to get a witness in your case. Do you have a witness? Yes, I have. But sasa sijui yako wapi. You see, it shows that you as a
As a victim.
As the victim,
yeah.
you need to be ready for these things. Like if you're in communication with your advocate, definitely the first person the prosecutor will go to is your advocate,
Yeah.
because they will not come to you.
Yeah.
They'll go to the advocate, and
advocate.
the advocate will hear.
Yeah, okay.
Yes, I think whole duty bearers,
Yeah.
we need to
participate
actively,
yeah.
and we need to have these conversations. And I'm happy that we're having these conversations. Yeah.
Okay. So just as you wind up on the victim,
Yeah.
with the victim rights, before 2014, the victim was not, because I think the act was enacted in 2014. Is it right?
Yeah.
So before that, the victim was just a person who provides evidence and all that. But now you're saying they can give what that report? What is it called? Victim impact
statement.
Statement.
Yeah.
What is that? Bwana prosecutor.
No, just before he goes,
Yes.
I can start it.
Please
because
start.
We are putting him
On the spot.
on the spot.
Yeah.
So a victim impact assessment is where it comes at the sentencing point, where the case has been heard, witnesses have been produced, both the prosecution and the accused have brought in their witnesses. And now this is the point where the judge or the magistrate wants to write the sentencing. Now this is where they may bring in the victim. The victim is given a chance to bring in now the emotional part of it. Now, what happened to you? Like that is why now that is why it is known as the victim assessment impact. The impact of that crime. What has it done to me? For example, I've lost the breadwinner in my family. I've lost a child. So I think it is now, that part is one of the, yeah.
Yeah.
And maybe
so
you
does the
can
court,
expand on it.
must the court always go with this impact? Does it impact on the decision of the court?
It informs
Yeah.
the opinion of the court, but it's not binding on the court.
Or it's not binding?
It's not binding on the
Okay,
court.
yeah.
And when does this is brought in? Even at the initial stage of the plea taking, of bail application, courts might also request that this matter that we get a report from the probation office to determine the suitability of the suspect to be released on a cash bail, or the accused person be released on a cash bail.
Yeah.
So the victim has a say during that reporting. The victim has a say during...
Is it a standard practice? Must the victim have a say? Are you compelled to have a say, or do sometimes just find
if the court
free
finds if the court finds reason to inquire the suitability of you being released on a cash bail, then it's a obligation of the probation office
Yeah.
to interview you for purposes of giving a balanced report. They also ask even the victim, the accused person family.
Okay.
During sentencing, the court might request pre-sentencing report. Then that also comes in to help in making an informed position. Why would that happen? Sometimes you might realize as a community, parties have tried to reconcile. That goes to the favor of the victim, to the favor of the accused person. Or out of that, the accused person has never been remorseful, or there has not been any attempt.
Yeah.
So that shows the militancy. Or number three, you might realize that the victim has not healed from this crime. So that tells you that the courts need to now balance. Is this person even fit then to be given a probation sentence? That is why that report is very critical. And more importantly, just before there are even circumstances where we're dealing with matters of children.
Yes.
So that report is also critical during the assessment of where the suitability of placing these children as a welfare issue or before the court makes a determination. So the victim is always an active participant. Maybe, as you put it, that is on the back burner, but is a very active participant in the whole trial process.
So then you brought something else. Then to what extent is a victim involved in restorative justice? Because nowadays we say that the criminal justice system is walking away from being too retributive. We want to be restorative. So the victim comes and say, enyewe Vincent hurt me, lakini mimi namwachilia. State inasemaje? Is this not where the state now invokes the republic? Sawa, mnaweza sameheana, but now there's the republic. Is it?
But maybe just to
Yeah.
to try responding to that,
Yeah.
we need to understand the before a court decides to dismiss the matter, because okay, I've come and said, me and Anita, we are okay, we've decided to
worked it
forgive
out.
each other.
Yeah.
But they have to understand why.
You
Because
give me money.
exactly. So if you've given money, then it shows then I'm not doing it out of my will. I'm doing it because you've given me an handout.
Oh, okay.
So, and on the other part, remember, at times our rights does not belong to us.
The republic is involved.
The republic is involved. Because the right to life,
Yeah.
you cannot decide to take away your life.
No. Suicide, is it?
Yes.
Yeah.
So at times, those are the thin lines between our rights and because the citizen has the mandate to protect its citizens.
So I, as a victim, may come up and say, we have forgiven each other, we are now friends, we have worked it out, but the state can still continue the case in the interest of the...
Two scenarios that might emerge.
Yeah.
There are cases where, and the ODPP is very encouraging, that if parties are reconciling, because that's really the real justice.
Yeah.
The real justice to them where parties are in harmony. But there are also cases where the DPP will not allow the reconciliation of that matter. Cases against children. Cases involving sexual violence. The court, the DPP and the law is restrictive on that victim choosing to say, now I am pulling back.
That has brought something to mind. Domestic violence. Tunaenda huko kwa polisi, mtu na bwana yake. Report. The minute the case is about to start, the wife says...
you might blame the wife.
Yeah.
But now that brings in a bigger picture. What if this man is the breadwinner? What if this man is the provider of the education of these children? What if we are in a rental house where in 2 months we'll be ejected out? So some of those reconciliations are influenced by a greater goal. And if that is justice, to both parties, so be it. Right? Sometimes...
I would want the state to stand in for me as the abused wife.
True.
Yeah.
We wanted to stand in. But then you have come in to say, this is the guy who flowed me from the street to stay in this home. I still love him.
That one we can discuss for days.
Let me just ask. Let me just ask before we leave this. I think it's a very complicated area.
Yeah.
Because, for example, we have communities who settle murder cases.
But that we actually said in this show that is not...
You remember before that?
Yeah.
So now I was asking, when, for example, if right now I'm a victim of violence.
Yes.
At what point does the state now comes and says, okay, as much as you're saying you're okay with your husband, we need to dig into this issue because it is affecting not only you, it is affecting your children and the rest.
Yeah. So when does the state decide to continue or not to continue?
Or maybe SGBV issues can be
maybe also treated differently.
Now, we had the response on that from Article 159 to 159 to 3. Traditional dispute resolution mechanism shall not be used in a way that contravenes the Bill of Rights. Is inconsistent with this constitution or any other law. That is already the first caveat. But then when does this alternative dispute resolution allowed? Article 159(2) of the Constitution stipulates alternative form of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanism shall be promoted. Right? But we are saying the law allows us to go that route, but it also ring fences.
Okay.
At what areas do we need to entertain those alternative dispute resolution? So it's not only at the discretion of the DPP per se, it is what the law says, and it is the DPP who now enforces that certain category of offenses we will not allow because they infringe on the Bill of Rights.
Okay.
Sometimes some of these cases involve children, and it's the parents who want to reconcile.
Yeah.
So where is the interest? That is how the state comes in to whip its authority, that there are category offenses which we will allow, but there are other category offenses which will not. Not because we want to, but because it is a legislative and a constitutional requirement on the part of us to enforce.
Okay, that's clear. Maybe just because you've talked about the victim a lot, maybe I think I was representing the victim for some reason today, but there are rights of the arrested persons that are in the Constitution. And sometimes when you read it, you feel as though these accused people are so well represented in the Constitution, they almost feel that they're so protected, yet they're the ones who have maybe committed a crime. Why does it feel so? The rights of the arrested person, and there are so many. Maybe you can just simplify, just bring out a few of these.
Rights of an arrested person. I want to make it as simple as possible. If right now I'm arrested, first of all, people arresting me, that is the police officers arresting me, they need to identify themselves.
And I've seen on Twitter some people saying that is never the case.
That is never the case.
Yes.
So, one, that is a right that has been violated.
Yeah.
As you're being arrested, you need to understand why you're being arrested. And they have the duty to tell you, we are arresting you because you've done this and this. As the arrested person, you have the right not to speak or to speak. But if you speak, they need to notify you that whatever you say
can be used against you
in a court of law.
Yeah.
Which is not the case in Kenya. We only see them in movies and in our constitution. Then, once you are arrested, you need to be booked.
OB.
Which at times doesn't happen because of malicious.
So a lot of sensitization needs to take place.
We need to put that, because OB is part of the documents that are presented in court.
Lakini Vincent, so I have been arrested. All that was not done. Where do I complain? Who will help me?
You need to raise that in court.
After I've been taken through the process until I get to court is when I can now say, and I didn't even know why I was arrested.
Because if already they are violating all these rights, do you think they can listen to you?
No.
They can't.
Okay. So what happens when the court discovers all that was not done for me? What happens?
Two things. I think we also need to ensure, and I brought it earlier in the discussion, that we also need to ensure that the suspect is informed of this.
Yes.
Almost always, you will be informed. Almost always. The only issue will be that you are not satisfied of why you are being detained. And it's always a defensive mechanism. If it is a traffic offense, the officer will tell you your brake lights are dysfunctional. If it is a restriction to COVID regulations, they will always tell you. But just because at that stage you want to be militant, most times people don't get it that way.
Listen to this. Janet Kilel said something, and Maina Muhindi on Twitter. But mostly, you will be arrested, and when you ask the reason, most common answer is utajulia mbele.
Exactly.
True.
Especially for petty offenders.
Yeah.
True.
Yeah.
For petty offenders.
And just wait, some handle says, what nonsense is this now? That's his handle, not like this discussion is nonsense. They say, try using this on an officer, it is almost laughable. So clearly, it doesn't really happen. So the question is, what happens when you discover you've taken a case to court and this was not done?
If the infringement is beyond a constitutional right,
Yeah.
then you have a remedy to seek a civil remedy, to seek a parallel compensation from the part of the government.
Yeah.
And that has happened. There are officers who have been fined for infringing the rights of even the suspect or accused persons.
Yeah.
So that's another regime of
Okay.
law altogether, where
Alright.
the court, the government will compensate. But more importantly, I wanted to bring out
Yes.
that when there could be environments where you will not be given all that information at the beginning.
Yes.
If, for instance, we use the scenario of an allegation that you stole a cow, at the time of arrest, the officers might tell you, we are detaining you because you stole a cow. Where did you steal it from? Who is the complainant? That information, you will get it at the police station.
Okay.
So what I said, you get as snapshot of what you are accused of committing might be very scanty at the time of arrest.
Yeah.
But at the time of booking, you will always find that information. Or at the time of recording your statement,
Yeah.
you will always find that information. And the way it is not presented, you also have an absolute right to getting the information of what the state has against you before a trial. So at the police stage, at the time of you are being asked to take to answer to the charge, you will also be presented with evidence which the prosecutor has,
Okay.
right?
Yeah.
Which is available at that time, so that you will also appraise yourself that you are accusing me for this offense for this reason, because it is so and so who stole it from you,
Yeah.
who raised the complaint.
Yeah.
So that safety net is provided for, and more importantly, that even where there is an infringement, even at the police station, the suspect has a right to convey that communication to the court. The court can order for an investigation and an inquiry into that allegation and get its finding. Right?
Yeah, but are you feeling there's a gap, because there are people who definitely can pursue this part that my rights were infringed and all, but kuna ule boy wa mtaa, maboy wa mtaa, the ones who are holding to cells
Yeah, the petty
on
offenders
Friday,
on Fridays,
and
yeah.
then so that there is that the wet areas now come up for corruption, and you're told Saturday, Sunday ukitaka atoke
Yeah.
pitisha pesa. And I've seen a person on Twitter, Felix Maranga, saying we need to digitize the OB.
It is already existing.
Oh, nice.
Yeah, the digital OB is already existing.
Okay.
Yeah.
It has, they've launched it, but it is not in all court stations.
Okay.
Police stations.
Police stations,
sorry,
yeah.
police stations. You realize we only maybe have very few police stations who have digitized OB.
How does a digitized OB work? Why do you think it prevents corruption?
Maybe if I may.
Yeah.
You see, once we have a digitized OB, we can have information maybe stored better, in the sense that tampering with digitized OB
It's difficult.
is difficult as compared to just a paper,
Yeah.
which can be,
Yeah.
yeah. And I think the other thing is maybe we need also to be very strict on booking people. You cannot have someone in your cells who is not booked,
Yeah.
irrespective of any matter that is there. If you need to book all, yeah.
Okay. So we're just winding up. Thanks, Omondi Austin Ouma. But then he says they stop being rights when dealing with university students. Donge. The rights when you are being arrested, those ones are not read out to university students. And then somebody else here, and I think we discussed that. Why is ODPP silent when it comes to restorative justice? That is what you're now pursuing, right?
Yes.
A lot of restorative justice. Because, like I think in a different show we were saying how we just see prosecutors as sharks, out to draw blood. So I think now we are trying to bring out a new face of the 21st century prosecutor, who is, first of all, restorative rather than retributive. We're just winding up, and I'm reading the comments on social. We may not be able to cover all of them. Luke, today we've seen your question, but I'm not sure we can. It is quite relevant to this topic today. But thanks for engaging. Ithe Wambesha. That means mtu wa pesa.
Baba wa pesa.
Baba wa pesa, asante sana kwa kufuata. And there are so many more on Twitter also who have just been engaging on this topic throughout the week. We have limited time, so we have to come to an end. I was wishing we've really talked about the victim. And maybe we now need to create time and talk about the arrested person. Yeah.
And as well the whole gist of access to justice.
And
because
access
I
to
feel
justice.
it is a conversation we need to have.
Yes, there's so much more to discuss. And I just want to thank you for the few minutes that you've been here. And I will invite you again. Please allow me to invite you again, because this has to continue, especially on the rights of the accused, the arrested person. I keep calling them the accused person. The rights of the arrested person, and of course, access to justice and what the Bill of Rights says about this. So maybe just final thoughts. What are your final thoughts on all this? The rights of the accused, are we there yet?
We are not there yet.
Yeah.
We have a dream.
Is there hope?
That we need to live.
Yes.
If we want to achieve our dream as that country where we respect all human rights, then we have to start living our dream.
Yeah.
And how do we live this dream? It is ensuring that we take a multi-sectoral approach.
Any mongia kama boardroom, corporate talk. What is a multi-sectoral approach?
A multi-sectoral approach is where each and every individual has to play their role.
Okay.
They have to see this as we are working towards this goal and we all have to participate.
Yeah.
If I'm hiring an advocate, I have to give my advocate sufficient information. My advocate, you have to work with the prosecutor. The prosecutor, you have to.
Do you as ICJ do sensitization campaigns on this thing?
Yes, we do.
Yeah.
We, in fact, have paralegal networks in various counties who we train on different issues. For example, we can train them on pre-bargaining, we can train them on rights of arrested people. Then our paralegal networks will act as our focal point to the people, so that once we leave the local communities, then we already have stationed people there who can offer legal services to them.
Okay.
Yeah.
Final words. Are prosecutors sharks? Are you out to just draw blood?
No. The Office of Director of Public Prosecution carries two feathers. It carries the feather to protect the victim. It also carries the feather to protect the state. So it is a misnomer to call us sharks intended to draw blood.
Yeah.
If we were, we could not be proposing the recommendations of alternative to dispute resolutions. And the office is very active on it. But we are not saying we are going to swim into the interest of the victim per se, because sometimes the interest of the victim is not the interest of the state.
Yeah.
So sometimes that's how the office has to balance those. But as an office, we are also alive that we might not be doing things as per the standards. You also have, as a victim, an opportunity to write to us, or as an accused person to write to us and say, can you look at this matter? We have the decision to review. And the office can make a different approach, having given another considered observation. So we are an open office, a public office. Please visit and please visit and don't see us as a militant institution.
Good.
Thank you very much.
Thank you so much. So I think we are all in the process, in the journey of interacting with the criminal justice system differently. They are not sharks. They are out to help. They are meant to represent us and, of course, the state. It's a very delicate balance, as you've heard him say, and it's an ongoing, it's an everyday affair. So it cannot be, the balance cannot one day be achieved. It's a journey. And, of course, like Vincent says, it's everybody, the multi-sectoral approach. Everyone must participate, from the victim to the accused, the arrested, the advocates and the prosecutors, the investigative agencies. We must participate in this process. So we'll pick up this conversation again. Please continue engaging us on social. We will definitely respond to you, and we'll see when again to come up with this topic: the rights of the arrested and the rights of the victim. They must be considered in the criminal justice system. I want to thank you once again for engaging. This has been the ODPP Café Show. Comes to you every Friday from 8 a.m. to educate and inform you. Join us us again next week and see what we'll have in store for you. I wish you a good weekend, a restful weekend, and a blessed week ahead. Thank you very much.